particular the net present value issue or the discount factor. So I have three examples of like tables, three examples of different applications of the life cycle costing assessment. So I thought we could just very briefly just show those on the screen just to identify some different types of life cycle cost assessments. And then we have the actual topic for today, which is risk, but there's only 20 slides for that one. So hopefully we can sort of cram everything in together. But of course, as and when questions arise, I think we can take them or comments. So let me see where we are on this one. Okay, day 8. Day 8. Please bear with me while I'm trying to bring up my presentation.
Sure, thank you.
For today. Day 6. Open recent. Okay, 37. 37. Okay.
I can see it.
Okay, I'll now try to do slideshow. Slideshow. Can you see it?
We can see it, but yeah, I don't know if other people have any issues, but I'm fine.
Do you see me turning the slides?
I can see a slide called Works and Related Non-Consultancy Services.
Wow.
Your camera is off though, so you have turned the camera off, so we can't see your face. Yeah. I think we are good, Simon. Yeah. So we are slide number 26 right now.
Let me just see where I am. Slide 26. I want to bring it to slide 37.
Okay, we are good.
Okay. Oops. And now it's taken me back to, sorry. Do you see me turning the slides, Suman?
Yeah, we can. You are good. We can see you on slide 37.
Okay. Okay. I think actually we discussed this one on Mondays, so I think we can go ahead. This is the distinction between unit priced or bill of quantities contracts and lump sum contracts. I think we've covered that one as much as we can today. So let's move on to the next type of contract is cost reimbursable contracts, and they are exactly what they say they are, which is payment on the basis of reimbursement of the valid costs in implementation of the country, plus some sort of a coefficient for overhead and profit. Now, these types of contracts may have included in them a term as to the estimate of the total cost or some sort of a cap. Time and materials rate contracts. Again, these are contracts which establish rates for labor or other expenditure of time and materials. And again, there may be a ceiling price, which may be a hard or a soft type of a ceiling. The soft one being sort of, aspirational. Other contract variants, the design and build contract, along with the turnkey contract. We mentioned that in passing yesterday. Then there's the management contract, which is a contract in which the prime contractor essentially subcontracts all of the work, although the prime contractor performs management functions of coordination and monitoring of performance and ensuring the compliance with the contract, but the prime contractor remains wholly liable for the performance of the contract. We mentioned performance-based contracts yesterday, I think. Then there are so-called piecework contracts, which are contracts based on a schedule of different types of activities, which are then priced. And this may be used, for example, in maintenance and repair contracts. Contracts for consultancy services, the main types are lump sum, time-based, retainer and or success fee contracts, which are seen, for example, in the preparation of companies for privatization. Percentage contracts, an example of a percentage contract is architectural contract, which may be based on a percentage of the actual construction cost. Another example is a pre-shipment inspection type of service where the fee may be based on a percentage of the value of the shipment. And then there's indefinite delivery contracts, which bear some resemblance to the framework agreement type of scenario, although from a legal point of view, they may be different. Because a framework agreement, so-called, is not an actual contract. It's merely a structure or a mechanism for the conclusion of contracts in the future during the validity period of the framework agreement. Structure of standard contracts. So the standard contract documents in the standard procurement documents of the World Bank and other institutions, and now many countries who have adopted this type of system, there's the general conditions of contract, which are immutable and are not to be changed from one procurement transaction to the other. And those are accompanied by the special conditions of contract, where various details that are not defined in the general conditions of contract are specified in this special conditions of contract document. Okay, and I think probably all or most of you are familiar with that structure. Contents of contract. Now, I think the remaining slides just give an overview of some of the types of issues that are typically addressed in procurement contracts, be that in the general conditions of contract or in that, or in the annexed special conditions of contract. So terminology is one that I would highlight, and that's very important. Terminology. It's very important in a contract because it's based on the meaning of the key terms that are used in the contract, that the obligations of and the rights of the parties are actually defined. Another item to highlight is the listing in the hierarchy of contract documents. Basically, what that means is that there is an order, a hierarchical order of the various documents that make up the contract, that compose the contract, the main parts being the general conditions of contract and the special conditions of contract. Special conditions of contract, since they are more specific to the particular procurement transactions, have hierarchical importance over the general conditions of contract. Now, rules of interpretation, I would just highlight the Incoterms, which are, I think most people know what the Incoterms are. That's a very interesting topic. These are terms, common terms, or terms with common definitions that are used particularly internationally to define certain key rights and obligations of the party, in particular what is included in the contract price. So there are various types of ways in which these issues that are addressed by the Incoterms can be allocated either to the seller or to the buyer. And those issues that are regulated by Incoterms include, the delivery obligations of the seller. Where, at which point in the journey of the goods from the seller's place of business to the buyer's location or destination, at which point is it deemed that the delivery takes place, and at which point is it deemed that the risk of loss or damage to the goods is transferred from the seller to the buyer. Which of the parties is responsible for loading the goods at the point of their export, and which party is responsible for dealing with unloading the goods at the point of destination, and then the onward movement of the goods to their final destination. Those are some of the issues that are dealt with in the Incoterms. The Incoterms typically are modified every 10 years or so. They're prepared by the International Chamber of Commerce in Paris. Now, one thing I want to just emphasize, the Incoterms are not the sales contract. They define certain key terms in the sales contract, but they are not the totality of the sales contract. They're just one of the ways in which certain terms can be used with a common understanding in international transactions. Okay. Yes, so there's another thing in the general conditions of contract is the basic statement of the responsibilities of the seller or the contractor and the procuring entity. No, these are the basic obligations being, to perform this, to do the sale, and from the buyer's point of view, to accept the goods, to take delivery, and to make payment. But then there are a variety of other more detailed supporting obligations. For example, in a construction contract, the obligation of the procuring entity or the employer to give access to the site. Then there's the contractor's responsibilities for safety and security of the site. Those types of very important supporting obligations. Then there's the reporting requirements. The duty of the parties, in particular the procuring entity's duty to assist the contractor. For example, if the contractor has to apply for certain licenses or permits, typically in the general conditions of contract, the procuring entity will take on the obligation of assisting, using its good services to try to help the contractor so that the contract can be implemented as efficiently as possible. Some more general examples of general provisions are the documentation requirements. For example, the obligation of the contractor upon the completion of the contract to provide the procuring entity with the drawings of what has been constructed. Another issue with respect to documentation is who has custody and care for those documents, which of the parties, and then there's the issue of ownership and use of the documents. There's the anti-fraud and corruption clauses, conflict of interest rules, which are of particular, not exclusive, but particular relevance in procurement of consultancy services, confidentiality obligations, and then there's a variety of other related obligations which may be stated. For example, the proper treatment of personnel. Another thing that comes to mind as we're looking at this is, the contract would state or should state any sustainable procurement obligations that are included in the contract or in the obligations of the supplier or contractor. For example, if there's an obligation of the prime contractor to devote a certain percentage of the work to contractors, subcontractors, those types of obligations, or if there's a commitment on the part of the contractor to employ or to give a certain percentage of the value of the contract to women-owned businesses, those types of sustainability or sustainable procurement obligations should be memorialized in the contract.
Simeon, I'm seeing your slide 37. Is that the slide? Slide doesn't seem to be advancing.
I'm now on slide 48.
Is everybody seeing the slide 48, or I am
I'm
still at
seeing 37, so maybe it's.
Oh, wow.
I am also seeing 37. I can see 37 from my end as well.
I'm sorry, I've been zooming along here, zooming. I wonder why I'm not, would it help if I make the screen smaller?
You're right now. 47. You're just on
You see-
47. General provisions 3.
Okay, so I'm going to keep this format here, okay?
Yeah, okay.
Do you want me to go back?
No, for me it's right. I don't know.
Or should I carry on?
This one says 47, which is 3. That's what I'm seeing.
Yeah, that's the one that I'm on, yeah.
Okay, that's what I'm seeing.
So should I go back to 37 and just zoom through them so everybody sees them, or should I carry on?
You can carry on from here, and then
Okay.
if I see.
Okay.
yeah, fine.
So,
Yeah.
Yeah, I
some
think
more-
Elizabeth should move the slides when he's in the next slide. I think there's some issues. Yeah.
Yeah, so I hope everybody will get these slides anyway to have, right?
Yes. Everybody will get the slide.
Catch up.
Yeah.
So some more examples of general provisions in the contract. There's the joint venture liability rules, which is essentially the rule of joint and several liability of the joint venture as a whole, and each individual member of the joint venture for the performance of the procurement contract. The designation of each party's representative, which is, could be the project manager, depending upon the nature of the contract, or it could be the engineer in a civil works contract representing the procuring entity and supervising the work. Restrictions on assignment and subcontracting, the issues of suspension of contract, and applicable law. And corollary to that usually is a provision on dispute settlement. Okay, procurement requirements. Now these are the provisions in the contract that specify what the actual item is that goods, works, or services that is the subject of the procurement contract. So in goods or works contracts, those are typically technical specifications, drawings, and the like. And in consultancy services, it's the terms of reference. Another aspect of the procurement requirement that's specified in the contract is the timing of the delivery obligation. Then there's mentioned here also packing and labeling requirements. Let me see if I can make this a little bigger. Quality assurance and control issues. These are warranty issues. Basically, the obligation of the supplier and the contractor, because they're in essence, they're equivalent obligations, and that is basically the obligation of the seller or the contractor to fix whatever problems there may be in the performance, in the contractual performance. So if it's goods, it's basically to repair or replace the defective goods. And in works, it's a similar obligation, which is highlighted in particular in what's called the warranty period or the defects liability period before the final completion. All of those kinks need to be ironed out. And attendant to that, to these sorts of, to trigger the application of those sorts of warranty obligations, the contract will typically specify the reporting obligations. In other words, the notification obligations. So if the procuring entity notices that there's a problem in the contract performance, it should promptly, basically in accordance with the timeline that's established in the contract, notify its contractual counterpart that there's this problem, it needs to be fixed. Because if that notification doesn't take place, that may impair the right of the procuring entity to exercise its right to have, to the warranties, to the warranty obligations of the seller or the contractor. Then there are provisions on inspection and testing, basically, which are there's sort of like two types of provisions. One would establish the rights of the procuring entity in particular with respect to the inspection process, and the obligations of the seller with respect to inspection. And the obligations of the seller would consist of, on the one hand, the obligation of the seller to conduct or facilitate the testing that is specified according to the schedule that's included in the contract. And also the situation where there may be unplanned or additional inspection and testing procedures, which may be a part or in addition to those that are specified in the contract. And that type of additional inspection and testing raises the question of who pays for it. Who pays for that additional testing, and what are the implications in terms of time for performance if that sort of unscheduled testing, it may be disruptive and necessitate the need for additional time to quality assurance, sorry. Okay, warranty, quality assurance. This slide highlights the issue of measurement of quantity. And this would be relevant in the unit price contract. The second bullet point here is very important for time-based or cost reimbursement contracts, and that is the contract will include provisions relating to the cost control and record keeping and accounting obligations of the contractor or the consultant, so as to enable the procuring entity in exercise of its right to inspect and to audit, to be assured that the charges or the invoicing based on time is justified by what has actually been performed by the contractor or consultant. So that's where these sorts of accounting and audit provisions come in. Another sort of quality assurance related issue is having to do with personnel. And typically that sort of provision empowers the procuring entity to request the removal and replacement of personnel, typically personnel that may be problematic for some reason. Okay, contract amendment. Okay, the basic principle of contract provisions on contract amendment or contract modification are or should be twofold. Or threefold. One, the basic principle that modifications of the contract should not alter the basic nature and scope of the contract. So it should be within the parameters. The contract modification should be within the parameters of the general scope and nature of the contract. Then the next part of these provisions has to do with, let's say, the contractual nature of contract modifications. Since a contract is an agreement between two parties, a modification of that contract logically requires an agreement between those two parties. So the general rule is that contract modifications should be subject to the bilateral, should be written and subject to the bilateral agreement of the parties. And there's an exception to that basic principle, which is particularly relevant in the construction context. And that is a contract provision that empowers the procuring entity or its representative to unilaterally without that bilateral agreement that I just mentioned, unilaterally order the contractor to perform certain changes, to changes in the specifications or something having to do with how the contract is being implemented. Now, the reason that the procuring entity is given such a power in particular in construction contracts is that there may be situations in which the procuring entity and the contractor are not able to reach agreement on the additional cost and or the additional time for performance that would be necessitated by a particular contract modification. That failure to reach agreement may be totally innocent. It may be due to the fact that there's like sort of a very urgent situation that needs to be addressed, something needs to be changed in how the construction is being done on a particular aspect. And there's no time, it's very urgent. So rather than having a problem and of delay in reaching an agreement, the procuring entity or its representative can order a change. That's referred to as a variation order. Now, sometimes internationally in practice, the term contract modification and the term variation order are used interchangeably. And that's I think somewhat unfortunate, because there is this distinction that I just mentioned, that the general rule is that contract modifications are bilaterally agreed and signed, but there is the exception for unilaterally ordered variation orders. That's I think I'll move on, but that's a very important issue in contracts, not only from the aspect of efficiency, but also from the aspect of integrity in the performance of contracts and in the procurement process as a whole, because as we know, for example, in the context of abnormally low priced bids, there is the corresponding risk of abusive use of contract modifications to make up for abnormally low priced bid having been accepted, where there may be some unscrupulous game going on. Okay.
Simeon,
sorry,
yeah.
I wanted to see if we can open up for some questions.
Yeah,
Sure.
Yeah, that's what I was going to ask Elizabeth.
Okay.
I think my colleagues in Nepal will agree that in Nepal there are a couple of big projects that are going on for more than 20 years. The project that is supposed to finish in 5 years, they are going on for more than 20 years. It could be because of the project financiers and meaning the banks, Asian development banks and the World Bank and the government and the contractor not functioning. It's a kind of a really mess how these contracts being implemented and managed. I'm particularly mentioning about this water project called Melamchi in Nepal. And I see a lot of weaknesses from the project management perspective in those contracts, as well as from the government side, who kind of oversee these contracts, the frequent transfer of the high-level decision makers, and they lose the institutional memory, and also, you know, involved in some, as you said, unscrupulous activities, you know. So
Mm.
there's a one project, I think, that is going on for almost 25 years, the water project in Nepal. So it's a sad situation, and maybe, you know, my Nepal colleagues can say a few words about their perspective, you know. Gorakji, or you know, who Saini ji, can you share some experience? You know, I think it might relate also contract variation and the payment and all that.
I don't have that much information about Melamchi, but what I know is that yes, of course, Melamchi contract is being extended many times, but last time it was terminated, maybe forfeited the security, I mean performance bond, something by the government, and new contract I think has been awarded. So that's all my understanding. But I want to know, I want to ask Simeon sir one thing. I right now I am facing is that we have a contract that before COVID-19 era for consulting service, assuming that some part they have to spend in the field visit, and but after COVID they perform the various tasks or most of the tasks by remotely, virtually. They consulted the stakeholders, and they they drafted the report. So they claim we should receive, we should be paid as if we fully comply the output. I mean, as if they have done everything as per before COVID situation.
Pre-COVID,
They are
yeah.
claiming. So how should we amend? How should we adjust that part? So thank you very much. Whether I make you clear my question or not. So if not, I will.
Well, your question is clear. I'm not sure whether my answer will be clear. I think it would not be via the price adjustment clause in the contract. It would have to be, I would say, via. I don't have the contract in front of me, so don't quote me, because it may be that some contracts, the individual items are quite easily divisible vis-a-vis the total price. So it may be relatively straightforward to remove certain activities which were impeded due to lockdowns and other COVID-related restrictions. But there may be other activities which were impacted and had to be done virtually, but nevertheless, you know, less work, less physical travel was involved, or so there may be room for some adjustment. But ultimately, I think it would probably be assuming that the contract has been implemented and was not, you know, the contract was not rendered impossible on like force majeure type of situation, but there were some limitations that impacted the total volume of work that could be carried out. I think that would have to be done via contract modification / negotiation type of process. Okay.
Oh, okay. Thank you. So we should negotiate, and we should, let's say that virtual work, how should we make the proportional or weightage, something like that. That is negotiation part. Am I
If
correctly?
I would say if the impact on the volume of work was not significant, then it probably is not worth negotiating about. Just pay it. But if there is a significant diminution or reduction in the amount of work that was performed because of the COVID restrictions, then I think there is a basis for a reduction of the price. So one has to look at the details of the situation and make the determination of what is the fair way to proceed, fair to both sides. Because we find, as we all find, is that so much of work that we used to travel for is now being done virtually. So I don't have a feel for what, in your case, what the particular impact quantity-wise and quality-wise on the work was due to the COVID restrictions.
So quality and quantity, let's say, same. But before COVID, we cost based on their field input, field visit, they will spend this much. So we estimate, and we awarded. Everyone participated based on that. Our open bid, I mean, this kinds of information, and they are awarded. Now they perform the things virtually. We cannot go very minutely the quality, because maybe if they consulted physically, some more information might be reflected in the study report, but we cannot go in that depth. But they claim full amount as per the original contract, but we are not in that position, because they definitely spend less and
Less time.
do not comply that field visit. So we are now somehow reluctance or somehow doubt we have to pay fully. So I expect from you how to adjust that part. Thank you.
Well, so if there was a measurable, if there has been a measurable reduction in the level of effort, then it should be possible to agree on the cost basis for for measuring the level of effort, and come to an agreement on a reasonable adjustment in the price. But this is not something that would be dealt with in the price adjustment clause. The only way to do it would be through I think you would best be served by having try to agree with the other side, right? Rather than having ultimately it may end up being a dispute if you don't agree, right? Which also has costs associated with it. So I would say the first effort should be to try to settle this amicably. And if indeed they did expend less effort, they had fewer costs. So at least the reduction in the price could reflect their reduced costs.
So I just want to know, this is the also subject of amendment or negotiation. So we can solve through this process. Is that okay?
I don't see the alternative. I mean, I don't see the alternative. I don't. To me, it doesn't sound like something that should be, unilaterally decided by one side, at least without trying to have an amicable agreement.
Okay, so, but
Okay.
thank you, Simon. Porsu Nepal, sir, just my colleague wrote that, yes, Italian contractor ran away from that Melamsi project, and he has many unpaid areas to the very various local suppliers, local worker, whatever. So there is a huge amount to be paid from that contractor. So whatever we forfeited is not sufficient. This is the current scenario, but already another contract is was awarded, and now we are hearing that the LMC project will be completed very soon, maybe couple of months. After couple of months, the tap will be effective to have the water. So this is the update. Thank you very much.
Okay, thank you.
In
Thank
addition of Parsu sir, in Melamsi project, there are a lot of things as a problem, like resettlement problem. Initially, they are land acquiring also problematic this project. Similarly, social cost like school establishment, road establishment, and other social activity are added for the project cost. Similarly, environmental issues are there. Another problem is conflict situation in Nepal in the name of civil war. A lot of struggle are there. Project implementation. In the project implementation, there are a lot of struggle part. There are public, local people demand so many more things, so that project period and cost both are rises.
Overrun, cost overrun.
Overrun, exactly overrun.
Yeah. Thank you.
Thank you.
Okay, thank you.
Thank you. Paris,
Okay.
did you want to say something?
No, I think, I think one thing I wanted to add on this topic, which Simeon is covering very nicely, is, on this contracts, many developing countries, contracting officials are not properly educated, trained how to interpret this international contract, the arbitration clause, and all that. I think there needs to be added emphasis on the local capacity building for this, the contract administration, contract management, procurement, and also, as Besi said earlier before, even in the project selection and project analysis, I think if a project is not selected, analyzed early on, a lot of this unexpected or undesired, unwanted problem will crop up later on, which might delay, which not might, would eventually delay the project execution and and all the contracting activities, that makes people as well as other parties, very unhappy, and even resort to court actions. Yeah. Just a comment.
Thank you.
Yeah. I think that's really true. What Parashu said, it's one of the, I think for IDI, maybe IDI can actually address this, because actually contract management is also a procurement planning issue, because it's in the procurement planning stage that the preparation stage that the procuring entity prepares the contract. And if the contract is not well drafted and sufficiently clear, that, you know, raises obviously the risk of problems in the contract implementation stage. So this is a good example of how the risks that are arising in the various stages of the procurement cycle are really interrelated, and it's very kind of circular. Shall I move on?
Yes, please.
Okay, so the next slide is about price and payment issues in contracts. Now, we mentioned yesterday already, so I won't go into it, the question of whether a contract is fixed price or subject to revision. And again, that's a risk allocation issue. We mentioned also yesterday, and I think today, about the Incoterms defining certain price and payment issues. The payment issue here is the question of whether it's the seller or the buyer that is liable for payment of taxes and duties. And those taxes and duties may arise at the point of shipment, or in the country of shipment, or in the country of destination. And then the last point here and subpoints are listing various other payment schedule and payment modality issues, for example, advance payment, progress payment, final settlement, the documentation requirements to be included with the invoice, and the issue of delayed payment and the sanctions for delayed payment. We all know that delayed payment is is a major obstacle, especially for the small businesses. So that's something critical. Next one, allocation of responsibilities and risks.
Sorry, Simeon,
Yes, please.
may I ask in previous slide regarding payment issue, what is the implication of payment into local? I mean, local mean that buyer or client country's bank. If consultant is working for, let's say, more than 6 months, they have a local joint venture or something, local firm, subsidiary, whatever they should establish, and whether we should pay in their local bank or in the case of international consultants consulting service, whether we should pay directly to the bank, to the consultant home country's bank. So what is the implication, not from the perspective of not only from the perspective of client, also I want to know from the perspective of consultant. So if you reply, I would appreciate. Thank you.
So what I understood from your question was that in this scenario, there's two parties, a local party and an international party. And the question is whether the payment should be made to
fully international party, but one provision, if I remember correctly, if the contract period is more than 6 months, then they should have local. They should establish local subsidiary, something like that. But this is not joint venture. Just for VAT or tax purpose, they should register for that VAT purpose. They should not have. It is not necessary to have local partner or JV. So in this case, I want to know this the tax implication. So
yeah, I can't give you specific opinion or advice on this without knowing more information. Now, but the example that you're raising is more than just a tax issue, isn't it? It's a question of some sort of a requirement.
Yes,
yeah.
Where is there a chance of consultant getting let's say, undue advantage of paying local, I mean, clients' bank, client country's bank, that is subsidiary bank, or their locally or temporarily established that sort of form bank, or directly to the consultant bank in their home country. So that thing I want to know. Thank you.
I don't know the answer to that question. I'm not familiar with that type of arrangement. I'm not questioning the existence of it. I'm just not familiar with it. For me, the takeaway would be from a payment point of view that the contract, and this is a very obvious point, but the contract has to be very clear on the issue of where the payment is to be made, to which bank or bank account, and what the tax liabilities of the consultant or contractor are. That's all I can say with any confidence about your example. But it's an interesting example that I would be curious about finding out more about. So maybe we can correspond about this offline. But the takeaway from the point of view of this sort of information that we're covering today is that the contract has to be clear about that. That's really what I can say with confidence. Okay.
Thank you. Thank you.
Any other questions before we move forward?
Yeah, go ahead.
Elizabeth, I'm requesting the participants from other countries also, raise questions or anything, I haven't heard from others today. Perhaps they are all happy and content, or
we are there, but we are listening to Nepal's experience.
Yeah.
Okay.
Maybe Simon, thank you for all these issues that have been coming up. I just wanted to share, well, not really share, but contribute something small towards the issue that Suman was raising, that, for instance, the World Bank project taking long to be completed, 20 years down the road. Well, what we are seeing back home here is that sometimes I think when they are designing these World Bank projects, maybe those days, they would require the local government, the borrower, to contribute a certain percentage, maybe 30%, and then the World Bank contributes a certain percentage. I'm not sure about this, but this is my personal observation. And you realize that what really leads to these projects lagging behind is this 20-30% contribution from the borrower's side. In most cases, this contribution goes to compensation of the affected communities in terms of relocation, in terms of valuation of their properties, in terms of redesigning maybe the roads of the new projects, for instance, infrastructure projects. And you realize that when the borrower, in this particular case, the developing countries, are contributing their 30%, there are a number of loopholes. The World Bank contributes is ready to contribute the 60% on time. But when it comes to this 30% contribution, for instance, if the 30% contribution covers compensation, and yet compensation comes up before implementation, actual implementation, you realize a lot of loopholes in compensation, a lot of failure, for instance, in negotiation with the landowners, cases dragging on for so long, going to court. You realize that, for instance, a government valuer who is supposed to come up with the official valuation position of maybe a piece of land where the road is going to pass, gives abnormally low prices to the extent that even the market price cannot accommodate. and this person takes for instance, the government to court. Things drag on here and there. He will give you this amount, and actually, because of this, there was recently a law, was it proposed or it was passed here, that, for instance, if the government values your land, if there is, for instance, an infrastructure project going through your land, and you refuse to accept the government official valuation value, the government will be forced to take over that one as and they deposit the money somewhere, I think in a court, yes. And if you're not satisfied, you can go on and take the government to court, but the government will forcefully take over your land and continue with the implementation of the projects, regardless of whether you are satisfied or not. So you can see most of the delays are actually on the side of the borrower. Failure to commit themselves to the actual terms and conditions, or even because of loopholes in the systems, like corruption, that actually tend to delay most of these projects. Whereas the other side of the bank, everything is perfect. That's something I just wanted to say. I don't know what could be your opinion, Simon.
Thank you. That's actually very helpful, that experience. And it's raising interesting questions that are not the subject of this particular topic directly, but are, I think, very, very crucial and typically come up in infrastructure projects, or let's say natural resources extraction projects, where the direct effect on the communities may be controversial. So that's very, very useful example. Thank you for that. Okay.
Thank you, Charlie, and thank you, Simon. We're about halfway through time, so we're going to proceed. If any questions come up, please put them in the chat or raise your hand. We'll open room for more questions. Thank you, everyone.
Thank you.
Thank you.
Okay, allocation of responsibility and risks. Now we'll be dealing a little bit more in more detail about the risk issue in the next presentation after this one finishes. But some examples of the risk allocation issue is the one we mentioned yesterday about the price revision clause in a contract, or the price adjustment clause. Another issue with respect to risk allocation is this allocation of risks of the type that may be grouped grossly under the notion of force majeure. Which are the risks borne by the procuring entity or the employer in the construction contract scenario, and which are the risks borne by the contractor. Then there are indemnification type of provisions, which are found in the general conditions of contract of the World Bank and other types of contracts of that nature and level of detail. And the two examples here are the one where there may be a question of violation of intellectual property or industrial property rights by virtue of the procuring entity's use of, for example, software or supplies of another type that it has purchased, and then there's a third party that claims to have intellectual or industrial property rights over that particular item that has been purchased in the procurement contract. And the procuring entity then, under the contract, is given an indemnification by the supplier to cover or to protect the procuring entity against any liability it may have to third parties with respect to violation of intellectual property rights or industrial property rights by virtue of the procuring entity simply, buying and using this item in accordance with the, the parameters of the procurement contract. Another example of indemnification is the contractor's indemnification of the procuring entity against third-party action for injury caused by, typically, for example, in construction contract scenario. Securities, okay, those are specified. The one that isn't specified, among the, the prominent bid securities that arise in the procurement scenario, the one that isn't dealt with in the contract is the bid security. The other is like the advance payment security, the performance security, and the retention money guarantee are all specified in the procurement contract. Okay. Let's see, insurance. So the next couple of slides outline the basic features of clauses on insurance. Now, again, here the Incoterms comes up because, as I mentioned earlier, one of the aspects of contractual performance and contractual rights and obligations that are defined in and allocated according to the different Incoterms is, whether the sale price includes, and to what extent it may include insurance for the transit of the goods from the seller to the buyer. What is the coverage? Then let's see, insurance. Yeah. So among some, in addition to what is covered, the scope of the risks that are covered, other questions that may be defined in the contract are the identity of the insuring party, who is the beneficiary, and then the documentation, the requirements to document and to keep up to date documentation concerning or proving the insurance cover. Delay and non-performance, these are basically issues relating to when the delay is excusable, and typically if the delay by the supplier or the contractor is due to circumstances beyond the control of the supplier or contractor, those are excusable delays. But again, here there is a notice requirement, just like in the case of warranties or performance guarantees or those sorts of things. There's a requirement that if there is to be a claim for a force majeure basis for excusing delay, that has to be notified. That has to be notified essentially promptly to the procuring entity. Otherwise, the supplier or contractor may actually be barred from asserting such a justification or an excuse for delay if there hasn't been proper notice of that situation given to the procuring entity or to the employer. The other aspect dealt here is liquidated damages or penalties. And those two terms are used interchangeably very often. The reason in some systems they use liquidated damages and in other systems they use the term penalty for the same thing, it's because there are peculiarities of the UK or US common law type of legal system and its terminology as opposed to other legal systems. So there are these different terms used because in some countries, in some legal systems, the legal system doesn't actually allow penalties for delay. It doesn't allow penalties for delay. So they came up with this term called liquidated damages, which is essentially either penalties or delays. They're pre-agreed amounts that will be due to the procuring entity for each time unit of delay in the performance of the contract up to whatever the ceiling is. And if that ceiling is reached, then there may be grounds for termination of the contract. Contract termination. So basically, these types of provisions in a nicely drafted contract should include not only the grounds for termination by the procuring entity, but also the grounds for termination by the contractor or supplier, because it should be a two-way street. And essentially, most grounds for termination of a contract are fault-based. Okay. Now there may be failure to perform. Sort of a fault-based one is also insolvency of the contractor. That is typically a grounds for termination of the contract. Again, here there are notice requirements. Okay, typically the right of the procuring entity to terminate a contract for the exercise of that right must be preceded by notice, a notice provision that the defaulting or allegedly defaulting supplier contractor is given notice in advance of the axe dropping on the contract. And that is a technique that is essentially not merely to provide transparency and due process in the management of the contract, but it also creates an opportunity for a notice, to try to save the contract, because maybe at that point there can still be some correction of the defective performance. Partial or complete termination, the World Bank contract documents distinguish between complete termination of the contract and maybe only termination of parts of the contract. Among the consequences of termination is the financial settlement. Even in the case where a contractor has run away, like from that the example, maybe it's not a good example, but even in the case, what I want to say is that even in the cases where there is clearly a default in the performance, and that default is the grounds for the termination, the defaulting contractor is still entitled to be paid for the work that was performed properly. Of course, any such financial settlement, any such payment to the defaulting contractor would be subject to deductions for amounts that may be due to the procuring entity by the defaulting contractor, and that financial settlement will figure out who ends up owing whom at the conclusion of these settlement procedures. There is, I don't know if it's on this slide, maybe it's on the next one, I'm not sure. There's also the question of, it is here, termination for convenience. It's the third sub-bullet point of the second bullet point, termination for convenience. And that is a right that ordinarily is not available to a private contracting party, either a private contracting party contracting with a public purchaser, or just two commercial parties contracting with each other normally don't have a right to terminate the contract for convenience. It may be, but typically it's not up to one of the parties just to say, hey, I'm walking away from this contract, see you later. But there is such a right for the procuring entity, provided, of course, that it's exercised in the public interest. For example, if the goods that the procuring entity has originally thought it would need and procured, if those are no longer needed, or if there is reallocation of budgetary funds, which precludes further financing of the contract, the procurement contract should provide the public purchaser with the right of termination for convenience. Okay, claims and disputes. Claims procedures. Those are procedures which establish a process whereby the parties may claim against each other for issues that may have arisen in the course of implementation of the contract. Those claims procedures, may ultimately result in a dispute. And so it's very important that the contract outline not only the claims procedure, but also the procedure for settlement of disputes. And that may be a 2 or 3 stage process for settlement of disputes. The first stage being amicable settlement or an attempt at amicable settlement, which is essentially, an attempt to negotiate the contract, the dispute, a settlement to the dispute. The next stage may be a conciliatory type of, it's still amicable, but there's a third party involved, which is a conciliator or a dispute review expert or a dispute review panel. Now called in the latest versions of the World Bank document called dispute avoidance / adjudication board. These are third parties that are identified and designated by the parties for the purposes of, number one, trying to prevent disputes. That's why it's called dispute avoidance. They sort of monitor the implementation of the contract, keep, get the regular reports and documents and stay abreast of how performance is proceeding, intervene when there may be some issues that could be resolved at an early stage without, flowering into a full-blown dispute. And then if there is a dispute, then recommending a solution, and that solution will take effect and become binding unless one of the parties objects to it. So that's why it's still called an amicable process, even though there's a third party involved, because that third party recommendation does not become binding if one of the parties doesn't accept it. And then it goes either to litigation or to arbitration, depending upon what the dispute settlement provision in the contract provides. The next slide is about the different issues that are in the special conditions of contract. I don't want to stop on this because I'm anxious to get to the next presentation. This is more examples of the types of issues that may be essentially defined in the general conditions, but specified in detail. For example, what is the rate of the liquidated damages penalty? What is the percentage? What is the definition of the warranty period, the duration of the warranty period, limitations on liabilities, details of insurance obligations, stuff like that. All of those can be specified or should be specified in the special conditions of contract. So that covers the slides from Monday. And we now, I don't know whether you want to stop here. It's now 10:30.
We can ask a few questions here. If you have any comments,
Okay.
then we'll proceed. We'll give about, let's say, 2 to 3 minutes to see what we can do for questions. I don't have anything in the chat. If you have any questions or comments, please unmute and ask the question while Simon is pulling the slides, the next slides.
Are you still seeing my screen?
Yeah, it's looking blurry. There's an image which is on my side. I'm seeing something else.
We have taken it out.
So let me share again. I'll share again.
Are you going to share the new one or the old one?
Yes, I'm now sharing the new one.
Okay, yeah.
Which
So
hopefully, do you see it now?
Yes.
Yes, that's good.
Yeah, I'll leave this. I don't want to mess with the other one because it wasn't working.
So if you guys have no question, we can proceed further. So if you have any question, please raise your hands or turn your mic on and ask questions.
Or if you have a comment, that's okay too.
I think we are good.
No, I still have those 3 examples or illustrations of the life cycle cost calculations. But maybe we can, if people are interested, maybe we can look at these after we run through, those after we run through these slides. Okay?
Okay.
Is that good?
That's okay, sure.
Okay. So this session is about risks in public procurement and mitigation steps. Now, most, if not all of these are found in the standard procurement documents of the World Bank, as well as in procurement systems around the world. So let's run through these. Again, we're going to be doing sort of a sprint, but if you have any questions, please let us address those. Okay. The first one in the overview that talks about operating environment risks. These are the capacity of the procuring entity, the condition and the capacity of the market, and another risk that's mentioned here is the SCA/SH risks. Now, this refers to sexual exploitation and abuse and / sexual harassment. And this is something that, as I mentioned, I think yesterday or Monday, the World Bank is now giving increasing attention to as part of the wider issues to be addressed through the procurement expenditures. And it's being, I don't know if it's a pilot, but it's now included in provisions in the latest version of the works SPD of the World Bank. And there's various obligations that are imposed on the contractor to have mechanisms to receive reports and respond to problems of this nature and complaints of this nature. And those provisions are being included in particular in environments which have a high or deemed to have a high risk of these sorts of problems and risks, okay? So the presentation looks at planning and preparation risks, solicitation and evaluation of bids, contract implementation, and integrity. Okay, so a few minutes ago, we mentioned the contract. Parashu mentioned, I think it was Parashu mentioned the problem of contract management risks. Well, as we said in that discussion, to one extent or another, project management risks can be traced to risks and problems in the preparation, in the planning and preparation of procurement, and even more broadly in the identification, appraisal, and design of the projects in which procurement is but one part, although, you know, a critical part, obviously. What's new since 2016 in this regard that I would just call attention to is the step that has been introduced under the new World Bank regulations and attendant instruments is the Project Procurement Strategy for Development, PPSD. And there's a more detailed version of the PPSD for larger projects and a less detailed, simplified or streamlined form of the PPSD for lower value projects or less complex projects. And basically what the PPSD process is essentially designed to have the procuring entity go through a process of market research and a definition of its procurement strategy for the purpose of maximizing value for money. And I would invite you to check out the World Bank website, where I believe they have more information on the PPSD. And it's you know, it's an interesting development. It adds time to project preparation, but hopefully, you know, saves time in the actual procurement cycle. Elements of procurement strategy and planning. Yeah, justification. Let me just focus on justification of the proposed procurement arrangement based on market analysis, risk and operating context and project's particular circumstances. So really what we see in the PPSD type of process, you know, is information gathering and evaluation on the context in which the procurement is to be carried out, so that specific decisions in the preparation and planning of procurement, such as the determination of the qualification requirements, the identification of the pool of potentially interested bidders, the choice of the selection method, even the choice of the contract form. Is it going to be price adjusted, or is it going to be a fixed price contract? All those decisions, are based on adequate understanding of the operating environment in which the procurement will take place. Planning and preparation.
Before
Yes.
we proceed, if you don't mind, we just have a comment and a short question from Johnny. Johnny, can you unmute and speak, please?
Hello.
Hi, Johnny. Go ahead and pass your comment and ask the question, please.
Hello.
Yes.
Am I clear today?
Yes, we hear you.
Oh. Okay. Thank you. There are situations around here. There are situations in Africa where it is almost understood that, okay, the World Bank will be responsible for this payment, and then the other payment is the local government. The local government looks to raise that money from their budget, but can't meet up with it. So the World Bank commits its part, and it is clear. But in the contract, the 25% can be reached to get a contract paid for. Is the contracting firm having a right to demand their payment from the World Bank?
That's an interesting
Hello?
question. The contract is between the procuring entity and the contractor. The World Bank is not a party to the contract, typically. So I would say that on its face, the answer to your question would be no, because the World Bank is not a party to the contract being between the procuring entity and the contractor. There are, however, complaint procedures which have been elaborated more fully in the latest version of the regulations. Oh, I'm sorry, I was off the video. Have I lost my, do you still see my?
I can see your slide and I can see your video. I don't know if everybody can.
I think I have to go back to sharing. I have to reactivate. So I think the avenue or an avenue for the aggrieved contractor in that situation would be through the complaint procedures. Okay. Hello?
Johnny, is that okay? Did that answer your question? Okay, yes, he's good. And I think okay. Joseph had a question. Did you have a question, Joseph? I thought I saw your hand up.
No, it's okay. We can proceed.
Okay, thank you.
Okay.
You can proceed, Simon. Thank you.
Okay. So this slide, planning and preparation risks, highlights a number of risks, some of which have actually come up today in the discussion. The sustainability of financing was one that was mentioned, in particular the co-financing obligations of the borrower government. Another example of planning and preparation risk is the rule against disaggregation of procurement. In other words, the artificial splitting of procurement with a view, with the aim of avoiding more stringent, more transparent, more competitive procurement proceeding, the splitting of procurement. I want to mention another risk. It's not on this slide, but it just comes to mind now. There's also a risk associated with the aggregation of procurement. In other words, let me say what I'm thinking about is the imperative or the impulse that may be in play or in the air to consolidate procurement as much as possible with a view to achieving economies of scale and price fixing. Now, how do I noticed my video just went off. I don't know what happens if I, okay. Start my video. So the risk that I want to mention is when there's an imperative to consolidate procurement, the risk of, let's say, high degrees of consolidation of procurement is that the opportunities for small businesses will be constricted. So this is, I'm still trying to get back to the sharing of the video. Do you see it now?
We see the slides.
Do you see slide 5, planning and preparation?
Yes.
Yeah.
Yes. But I think since the voice is very clear, we can proceed.
Okay, you won't see my lovely face anymore.
No, I mean, it appears to be either internet or some technology.
I don't know. It may be my own technological stupidity here that's at play. So do you see slide 6 now?
Yes.
Areas of risk mitigation?
Yes, we can see it.
Okay. So risk, example of risk mitigation, it's related, I think we're still in the planning and preparation, is the use of leasing, which in some cases, for example, in emergency procurement situation, may be an appropriate way of dealing with certain risks, including, the risk of unnecessary ownership costs, which to some extent may be mitigated through use of leasing technique. Another example here is the second-hand goods. Now, it still is, I think, but maybe a little bit more nuanced now. It used to be that there was this almost like a sacred principle that the procuring entity should never buy anything that is second-hand. Now that sort of principle is modulated by when one takes into account the environmental risks and costs that are associated, the impacts, environmental impacts that are associated with excessive contribution of public procurement to the waste stream of a country, to the garbage of a country. So one of the ways of mitigating that risk is to allow, in appropriate cases, secondhand or used goods to be procured. so that is something that is becoming more, let's say, more acceptable, given the proper safeguards to make sure that the procuring entity isn't being sold unusable goods or junk. So there are quality and technical requirements and warranty provisions that should be included in the contract that envisages such a strategy. With regard to the risk of inadequate capacity on the part of the procuring entity, maybe you heard about this yesterday when there was a presentation, I understand, on the new regulations. One of the I don't know whether it's proper to call it an innovation, but one of the elaborations that's included in the new World Bank legal framework for public procurement, or the more developed legal framework, is this hands-on expanded implementation support, HEIS. And in fact, what this involves is let's say, a stepped up, an increased availability on the part of the World Bank itself to give hands-on assistance to procuring entities which may have capacity challenges, or that may be in small states, or in fragile or conflict scenarios. The World Bank is willing to step in and basically, shoulder to shoulder, help the procuring entities in designing and conducting their procurement proceeding. And that's sort of new because there's an added emphasis on this now. Solicitation risks. This involves the risk here is the risk that the solicitation of participation of bids or proposals is not sufficiently broad, okay? And there are other, so the mitigation measure for that risk is having a hierarchy of procurement methods, with the ones that are the most open to participation. The ones that cast the widest net are the default method, so open bidding method. Or in the case of procurement of consultancy services, a method which has an open call for expressions of interest to be shortlisted. Now, another dimension of the solicitation risk is that, even if there are sufficient publicity given to the procurement proceeding, that there nevertheless may be the risk that there would be inadequate rates of participation, particularly by the types of bidders that a country, as a matter of policy, would want to encourage. It's local bidders, it's small businesses. So here, a risk mitigation measure that has been actually, even in the previous versions of the SPDs and the regulations, that is as an alternative to a bid security requirement, the so-called bid securing declaration, which is cost-free to the bidder, in the sense that there is no bank fee that has to be paid, because all the bidder does is sign a letter or a statement or a declaration that says, if I don't sign the procurement contract and I'm awarded the contract, I agree that I will be automatically debarred for a period of X period of time, whatever is specified in the declaration. Another solicitation risk that is the risk that, the risk that what the procuring entity solicits is sufficiently defined or sufficiently described so that the bids will be responsive to what the procuring entity actually needs, that the solutions proposed by the bidders will be responsive to the actual requirements. So that's the situation where, for example, in particular in the complex procurement transactions, high-tech or complex construction contracts, or procurements of that nature, where it's not advisable, even if possible, but not advisable for the procuring entity to fully define, on the basis of input specifications, what exactly it wants to buy. Rather, it may be advisable for the procuring entity to get feedback from the bidding community as to various possible ways in which the procurement need can be addressed, can be solved. And that's where multi-stage procurement methods come in. Another way of dealing or mitigating solicitation risks related to the point I just made is about how the technical specifications are formulated. And that's the situation where the emphasis in the World Bank system is to the greatest extent feasible, use output or performance-based specifications rather than detailing the input specifications, like micromanaging what exactly the supplier or contractor has to do to fill the procurement need. Leave room for competition among different possible ways of fulfilling that procurement need in how you formulate the technical specifications. Okay, value engineering. I think we talked about that a little bit yesterday. So value engineering is basically a procedure through which a bidder and or a contractor or supplier has the opportunity to suggest improved ways of doing something that is involved in the implementation of the contract with a view to saving time and or cost. And that, again, is another type of risk mitigation measure that mitigates the risk that the procuring entity doesn't have, as much knowledge about what it is that it's procuring and what the best possible solution might be, as might be emanating from the bidding community. Bid evaluation risks. The big one here, I think, is to mention in view of our time limits is the notion of substantial responsiveness of bids. And basically that is the notion here, the principle here, which is very much ingrained in the World Bank documents, is that the procuring entity should not exclude or reject bids on the basis of minor imperfections in the bids, so-called minor deviations from the requirements that are spelled out in the solicitation documents. So it's sufficient for a bid to be substantially responsive rather than being 100% photographic responsiveness to the requirements, because if the procuring entity follows a very absolutist approach to judging the responsiveness of bids, it risks rejecting bids that may have some minor deviations, but are substantially or materially what the procuring entity is looking for to buy. And so from value of money, but also to limit the possibility that there may be mischievous rejection of bids on the part of the procuring entity to favor a particular insider on the basis of some hyper-technical, almost meaningless deviations in bids. So it's a multi-purpose type of mitigation measure, risk mitigation measure, this notion of substantial responsiveness of bids. Now, I won't go into it, but just to mention, there is the question of quantifying the impact of these minor deviations on the comparison and ranking of bids. Not all deviations should be ignored. Some minor ones can be ignored because they don't impact on the fairness of the competition to other bidders, and they don't implicate additional costs for the procuring entity. Some do, but some don't. Those that implicate quality considerations, even though they're minor, and may implicate additional costs for the procuring entity, those considerations, those impacts should be taken into account in the comparison and ranking of bids. They should be evaluated, even if they don't result in the rejection of the bids, just out of fairness to the other competing bidders who may not have such deviations, and also out of fairness to the procuring entity, since some deviations, even though they're minor, may involve additional costs for the procuring entity. So those should be taken into account. Okay, just to mention, I won't go into it, is the risk of front-loaded or imbalanced bids. And those are also the subject of mitigation measures in mitigation provisions in the standard procurement documents of the World Bank. Then there are transparency-related risks and remedies. Let's see, what do we have here? Publication, yeah, the transparency-related risks. So there's various publication requirements and various notices that have to be issued pursuant to the standard procurement documents of the World Bank. You know, for example, results of pre-qualification proceedings, notices of contract award. Another one on this page is the technique of debriefing of unsuccessful bidders following the issuance of the notice of intended award, which we mentioned. Actually, there's a repetition in the slide here: notification of intention to award, notice of intended award. I think it's meant that those should really be consolidated. Sorry about that. Compliance and accountability risks. Yeah, now some of these mitigation measures are found in the, you know, in the standard procurement documents, as well as the legal agreements that govern the financing of bank projects. I'm thinking of the no objection procedure, where certain decisions have to be approved, or at least you know, shown before they're finalized to the World Bank on a ex ante basis, before they're actually decision is made on this or the other aspect that is subject to ex ante no objection procedure. But let me depart from the road here a bit. This ex ante control is very important across the board in public procurement systems. And one of the things that we have noticed in assessing procurement systems around the world is that in some scenarios, in some regions in particular, the structures and the procedures for internal controls in procuring entities are not either are non-existent or not well developed and not efficient. And that the lack of such adequate internal ex ante control procedures, you know, it creates various risks for the procuring entity. Those risks include, you know, problems in the various stages of the procurement process if there hasn't been internal control before those steps are taken, whether it's signing, whether it's advertising, you know, is there an ex ante control before you solicit that the money is budgeted for this procurement? Ex ante control before the contract is signed, ex ante control before payments are made. And to the extent that there's an ex ante weakness of ex ante control in procuring entities, that creates a vacuum. And sometimes that vacuum of internal ex ante control in procuring entities is actually filled by external players, by centralization of control procedures, which has, you know, other impacts on an efficiency perspective, because to the extent that you have external controls, you know, there may be bottlenecks and stuff like that. Another key step in mitigation of compliance and accountability risks is, of course, the complaint review procedure and the debarment procedure with respect to conduct or misconduct on the part of bidders, suppliers, contractors, etc. Then from donors point, where did I go? From donors. Sorry, I've contract implementation. I think I jumped. Forgive me. Yeah, I just want to mention here donors' right to inspect and audit. Now, obviously, as you know, in World Bank financed procurement and similar types of scenarios, the contract and the other documents in the procurement will give certain rights to the donor to inspect and audit the procurement process. Choice of contracting approach. Now, yesterday we discussed the difference between lump sum and unit price contracts, and that's actually a risk. That part of that is part of the determination which type of contract to use is based on a consideration of risks. What is the risk of associated with inability on the part of the bidder, or for that matter, the procuring entity, to foresee exactly the level of effort that will be required. So in that type of a situation, it may be that a unit price contract is the most appropriate one from a risk mitigation point of view, including the risk that if the bidder is given an inordinate amount of the risk to bear, that additional risk will be calculated by the bidder in terms of a higher bid price. Fixed price or adjustable is another important risk mitigation measure related to the risk of price fluctuation. Framework agreements, they address the risk of the unpredictability that a procuring entity may have, or multiple procuring entities may have, as to the time of the times when recurrent procurement needs arise, as well as the quantity in which those recurrent risks, recurrent purchases may require. We're just mentioning here allocation of risk in PPP contracting. We haven't talked about PPP contracting, but it's a big issue. Just to note it, and that's a whole separate discussion. But it's a procurement issue because PPP is a procurement issue, but that's to some extent in a different sector of procurement. The level of detail in the contract obviously should be correlated to the complexity of the contract and the risk that is involved in the contract. And I just want to say as a general disclaimer or caveat that this particular notion that depends on the risk and complexity of the contract defines everything in procurement, in the sense that it defines the degree and intensity and detail of the planning and preparation that is required. It implicates or impacts on the intensity and detail and complexity of the procedures in the acquisition phase of bidding and awarding the contract, and definitely impacts on the drafting of the contract and the procedures and level of effort required in managing the implementation of the contract. Delay, the risk mitigation measure. Well, the most visible risk mitigation measure is liquidated damages or penalty clauses. But if we look a little bit deeper into the issue of the risk of delay, there are other risk mitigation measures that come in earlier. For example, the one we already mentioned, having the capacity for management of contracts, ensuring that the contracts are well drafted, because those types of shortfalls can contribute directly to delay. So this illustrates how some of the problems that arise and the risks that arise in contract implementation, although they are addressed by, you know, the very visible type of technique like price adjustment or liquidated damages and penalty clause and you know, dispute settlement clause, let's say, or stuff like that. There are other steps, you know, at earlier stages beneath those surface remedies that are equally important and actually, you know, as a prophylaxis to problems, for example, like delay. Performance risk, advance payment security. Okay, that's to ensure that the advance payment is used for the intended purpose. Performance security. Joint and several liability of joint venture members. I think everybody knows what that refers to. That means the procuring entity, in the case of a default, can go after the joint venture or any individual members of the joint venture for the totality of the liability. And there are others like pre-shipment inspection that are mentioned here as well. Some more examples of contract implementation risks and remedies. Insurance. I mentioned the indemnification for copyright and patent infringement. Dispute settlement clauses, we touched on that a little bit. Termination for convenience, which is a right of the sovereign purchaser, typically not the right of the private sector counterpart to the contract. And the termination for convenience covers risks like the risk that the procuring entity no longer needs what is being procured under the contract. Now, there's a sort of in the same neighborhood of termination for convenience, there is, in the context of emergency procurement, it's not exactly, I don't think, like the termination for convenience scenario, but it's similar. And that is that in emergency procurement contracts, it's probably advisable in most cases, if not all cases, in contracts concluded in, for example, in the immediate aftermath of a disaster, to include a clause that gives the procuring entity the right to cease further supplies. So, for example, if there's certain medical equipment that has to be procured to respond to a disaster or an emergency, but then at a certain point in time, that contract continues to be valid, but the emergency has ceased to take place, or the emergency response has moved on from the immediate aftermath to later stages in emergency response. So the original supplies are not needed anymore and don't need to continue to be delivered. There should be a right to, basically to terminate that contract. Contract management plans. This slide highlights the various ways in which contract management plans and the details that are included in the contract management plan may address risks. And the first one is actually the most, well, they're all relevant to risk mitigation, but the first one is interesting because it talks about, various risks that may arise at the outset. For example, delay in the contractor's right to access to the site, then payment delays and other types of defaults. Let me see, what we can do. Contract monitoring. Well, yeah. Now the contract monitoring is essentially, I think, the takeaway from this slide is that contract monitoring is in effect, it's like a super important risk mitigation measure because what the procuring entity is doing in contract monitoring is keeping its eyes on the performance of the contract to be able to identify any risks and manage any risks that may arise in in the course of trying to obtain performance of the contract that is compliant with the terms of the contract, and that it ends up getting value for money, that it ends up obtaining what it is paying for. I'm thinking of a couple of things right now. One is that the risk of non-performance, or the risk of abuse, the risk of corrupt practices. Those, as you know, are not confined to the process of awarding of contracts, but maybe even as important or greater in the course of implementing contracts, where all sorts of chicanery may take place. So in terms of the risk of abuse of that sort, contract monitoring is crucial. Another, I don't think it's mentioned on this slide, another risk that arises with respect to contract monitoring is the risk of the inability of the procuring entity to monitor the contract. Okay. What this slide talks about is different aspects of risks that may arise in contract implementation that are mitigated by monitoring or being alert or vigilant for such risks. For example, the time risk. Okay, the risk of undue or inappropriate contract modifications. The risk of the risk that the performance ultimately delivered is not compliant or is not acceptable. The risk that I'm thinking of is before you even get to that, the risk that the procuring entity won't be in a position to monitor the risk the contract performance. And again, that's a risk that's elevated in the context of emergency procurement, where the conditions for contract monitoring may be difficult, if not, definitely an obstacle. So there's certain techniques in terms of technology that may be used as risk mitigation measures, and that the World Bank promotes. For example, the use of mobile and geolocated mobile devices for the purposes of monitoring, the engagement of third-party monitors, the engagement of civil society organizations to monitor performance of contracts. Integrity risks. So there's various techniques that are designed to support integrity in the procurement process. They may support other important objectives, such as transparency, but they're sort of looked at here through the optic of integrity. One is public bid opening, restriction on negotiations with the BAFO technique as one way of enabling negotiation, but at the same time trying to mitigate risk of abuse in negotiation, which is elevated through the best and final offer technique. Then the World Bank, of course, has its anti-corruption guidelines, which are incorporated by reference into the World Bank finance procurement contracts. I mentioned already civil society monitors. Another technique that has been introduced into the World Bank system in particular for mitigating risks associated with negotiation is the probity assurance provider or auditor, a third party that sits in on negotiations between the parties and can vouch for the integrity of that process. Donor fiduciary risk is the last one that's mentioned here, and that basically refers to the obligation of the World Bank as you know, as the financing institution to its member states who provide the money to ensure that the money is properly spent through, in particular, in the procurement context. So what has happened with the introduction of the new legal framework is kind of an adjustment to the practice of the World Bank, in that it is now embracing on a wider scale a sort of a risk-based approach to the prior review and no objection procedure, so as to focus in those sorts of prior control procedures of the bank on higher value contracts, rather than on, you know, casting a wider net. And that's for the purposes of essentially for efficiency. Okay, that's the last slide of this set.
Thank you so much, Simon. This was great. If you can stay on for a few minutes, that would be great. I just have 2 questions from Charlie, which I would ask for Charlie to make them brief. Charlie, can you unmute and ask your questions, please?
Thank you, Simon, for the presentation. The first question is in regard to contract monitoring risks. I was just wondering whether we could as well come up with a joint monitoring team rather than putting all the responsibility on the borrower, and we have a joint team between borrower and the donor, or even creating a contract monitoring desk, which is housed in the borrower's premises to monitor the contract on day-to-day basis on behalf of the donor. Or like what you mentioned at the very end, having a third-party monitoring company. But you know, these third-party monitoring companies also have their own risks that you're also bringing on board. And then the second question, let me see. Oh yes. I was also wondering.
Can I just take? Can I just take the first part of the question first?
It's okay. It's okay. Perfectly okay.
Yeah. I just want to say that I wouldn't be able to answer your question authoritatively, but I think that there might be, under one aegis or another, for example, like under the aegis of the hands-on expanded implementation support procedure that I mentioned earlier, there might be an opportunity through something like that to have some sort of a joint monitoring activity feasible. And of course, the World Bank, you know, itself has its own fiduciary obligations in terms of monitoring how procurement is carried out. So there may be some avenues via that as well. But I don't want to say authoritatively on behalf of the bank one way or another, without knowing more about each individual scenario in which such an idea comes up. I'm sorry to interrupt. Go ahead with the second part of your question.
No, that is perfect. Okay with me. The second one is in regard to the formulation of a procurement risk register. Has the World Bank thought of or advocated for a procurement risk register? And does it have, for instance, a comprehensive procurement risk manual? Because in our case here, actually, we have just completed an assignment where we are incorporating, first of all, we are formulating a procurement risk management manual in our public procurement, and we want to slightly move away from the risk-based approach to activity risk-based, where we are assessing the risk for each and every activity for the entire procurement cycle. to be incorporated throughout the entire procurement process, which we are yet to roll out.
I know
So
that the World Bank has systems that they apply for the activity of risk assessment of projects as part of the project preparation, identification and preparation process. As far as the specific issue of risks in using risk-based approach in prior review of steps in the procurement process. I don't know whether I know that this is an approach that the World Bank is now emphasizing pursuant to the new legal framework for public procurement that they've developed. I'm not sure whether they have, I don't know whether they have any more specific instruments or guidance, but I can try to look into that and get back to you to see if I can find anything.
Okay, thank you so much. Thank you. And Charlie, if you have additional questions, please feel free to email me. I'll make sure that the trainer gets them and replies. If there are final questions from anyone, you can ask this time before we close. If there are any questions, if not, I'll ask Suman to say something before we close.
Elizabeth?
Let's take one or two questions more, maximum. So if anyone has, please raise your hands or turn your microphone on and ask a question before we let Simon go, because he's not easy.
Okay, I can say. I had those 3 slides about the life cycle costing. I can send them to you and you distribute, or we can show them now, whatever people.
Elizabeth can distribute that. Elizabeth can distribute that. Yeah.
Okay.
Okay, so it looks like there's not much questions anymore, but I think, Simon, it was like really a very insightful presentation. I'm not by any means, I know even 1% of procurement, but I thoroughly enjoyed it myself. And I hope it's the same story with the rest of the folks here. And if it was a year and a half ago or a year ago, because yesterday was an anniversary of the lockdown in US, at least, kind of anniversary we call it, and otherwise we would have given you a standing ovation right now. And with that, I know you are always there. Simon is also our course advisor for this, and he really helped us move forward with this program. And thank you, Simon, for everything. And if you have any question, please send it to Elizabeth, and she will make sure that you get the answers, even if you couldn't have a question today. And just some housekeeping, that please send your reviews, because they are very important for us. And also in reviews, if you think that some new topics should be added or something else, you can put that in additional comments, and that will help Elizabeth for the next quarter's program. And the third but not least is on Friday. I'm not sure, but I would like to suggest you to please plan for 15 minutes extra at the end, because we have gone over about 15 minutes on Friday's program, because we're going to bring few panelists, and hopefully we'll bring Simon back too. And so that's with that, I think we are coming towards end of the program. Elizabeth, anything to add before we let everybody go home?
No, we are okay. You've done well on the evaluations. Thank you. I'm only missing one, so I would ask that person to submit that. Thank you.
And we should take a group picture today with Simon. So let's turn the camera on. I can see Charlie. Are we missing just few? Parashu, Bridget, Wally, and Gorakji.
Oh, and Jack is here too.
Yeah. So You know, we use LinkedIn. I've been like posting updates on LinkedIn, and that's the best way to follow us. Even though we are present in Facebook, but you know, LinkedIn is more updated than Facebook more often. So with that notes, thank you very much, and see you all tomorrow.
Thank you.
Thank you.
Thank you, everyone.
Thank you.
Thank you, Simeon.
Very much.